You can grab something to eat outside and come back to the committee for our meeting. Thank you very much, honorable members. You are all welcomed to this subcommittee meeting on rules. As we met, I think it was last week, we agreed on certain things that were needed to be done, and those matters were attended to. We allowed parties to make their own inputs so that those inputs will assist on the work that is expected to be done by the parliamentary team, the parliamentary legal services, together with the National Assembly table staff. So we appreciate that. I want to believe that we all received the documents. If there is anyone who didn't receive anything from the members of parliament, you can indicate, but I know for a fact that documents were sent to all of us and we were able to look into the documents. Honorable members, with that being said, can we now, I don't think we have apologies. Honorable Manyi is here, Honorable Matias is here, so all of us, we are here. And in this meeting, we don't need a quorum because this is a processing machinery for the Rules Committee. So is there a mover for the adoption of the agenda as is? Everything was sent to us. Honorable Michalakis moves and Honorable Ghana seconds. Honorable members, without wasting time, I will now hand over to Mr. Kaso to take us through the next item. Mr. Kaso, over to you.
Thank you so much, Honorable Chairperson, and good afternoon, honorable members. Ma'am, we, as directed by this committee, on the 29th of May, we circulated the proposals to the members of the committee, and these were the two documents that we have again circulated today: suggestions for amendment of the presidential impeachment rules. It's a document with 7 pages, and another one with 39 pages, I think. It's detailed rules governing the Section 89 inquiries. We've also, for the information of the members, circulated the submissions we received from the parties. We have copies of those documents here, should members wish to consult the documents. Ma'am,
maybe a point of before, my sincere apologies, Mr. Kaso. My sincere apologies, honorable members. We were supposed to clear our table as there were allegations made against the speaker by Honorable Michalakis. Then Honorable Kwarenov, as the parliamentary counselor to the president, he then wrote to me a letter clarifying that matter. And he indicated to me first on the same day telephonically that he couldn't respond. He was on the platform, but he couldn't respond at that particular time because he didn't want to disrupt the meeting. So what he said on that letter is that the speaker didn't meet with the parliament. Parliament. Remember that the word parliament will always pop up in my mouth. So he clarified that the speaker did not meet with the legal advisors or the legal representatives of the president. He therefore requested that as the chairperson, I must also circulate the letter to all members of this subcommittee, of which I did. Thank you very much. You may proceed, Mr. Klaso. I wanted just to clarify that. Thank you.
So ma'am, the legal team is here. Advocate Breitenbach will lead the presentation of both sets of rules for consideration by this committee. Thank you.
Advocate Breitenbach, I want us to take it step by step. We start with the suggestion for the amendment of the presidential impeachment rules. Then, after we dealt with it, we will go to the thick document. Thank you very much. Honorable Manye.
Yeah, thank you, Chairperson. Chair, I was wondering if you could indulge me. Remember when we left here and we said there's a lot that we discussed. We're going to go and reflect, get advice and everything and all of that. So we have a view out of that process from this committee that if you indulge me, I would like to, I'm requesting an opportunity, couple of minutes to just express a concern in terms of how this process, the trajectory of this process towards the impeachment committee.
Honorable Mika Masaule.
Thank you very much, Chair, and greetings to you and greetings to members. I think it will help if Honorable Mani indicates on which item of the agenda that we just adopted he wants to speak on. We can't be all over and request a few minutes to reflect on our views. We just adopted an agenda item, an agenda that we should follow. I'm at a difficulty to understand which item of the agenda he wants to speak on.
Thank you very much. I thought I was just listening to all of you, honorable members. I think this is the subcommittee on rules. It has got nothing to do with anything. Ours is just to process the rules. If you have anything to raise, maybe you should find space in the presentation when you participate, you make your inputs, then you can raise that concern. But if it's not about the rules that we are about here, I will not put any other item on the agenda as it has been adopted. And remember, this committee works only on referrals by the speaker. We don't come up with our own agenda items. So you can put whatever you want to put down. Then when it's time for us to make inputs on the rules, if it concerns the rules, then you can make that input of yours. Thank you very much. I want us to proceed, Honorable Mani. I want us to proceed. You may speak.
Yeah, thank you, Chair. No, Chair. Yeah, what I want to speak to is to do with the rules process that we're embarking on as it relates to the Constitutional Court judgment.
Okay. Honorable Mani, I want us to allow the advocate to make the presentation on this set of rules, the suggestion on this set. Maybe you will get your response when he make his presentation on the rules. Can we allow that process, please? Please, Honorable Mani, let's allow that process to take place. Thank you very much for your understanding. Advocate Breitenbach.
Madam Chair, thank you. I've been asked to deal first with the suggestions for the amendment
Uh, Senior Counsel, please speak to your mic. Yes, thank you. Thank you.
Apologies. You've asked that I deal first with the suggestions for the amendment of the presidential impeachment rules of the NA, following the judgments of the majority and the order of the Constitutional Court in the EFF matter. That is the 7-page document to which the Secretary has just referred. Those amendments are aimed at 3 things. The first is there are certain technical corrections to ensure consistency of language in the main Section 89 rules, for instance. The second is to align the rules with the outcome of the proceedings. And the third, and this relates of the Constitutional Court proceedings. And the third is to ensure the consistency of these rules with the impeachment process as it stands, if I can use that phrase, after the Constitutional Court judgment. And I'm referring particularly to proposed changes to Rule 129P. Now, each of these changes is set out in the format that you will have there. For instance, in the first one, that the definition of a Section 89 inquiry in the existing rules be replaced by a proposed new definition, and you will see that that refers in terms to Rule 129I, sub 3 and 4, which are the provisions written into the rules by the Constitutional Court in its judgment to provide for the referral of a motion for the removal of the President from office, its referral to the Impeachment Committee. Unless you would like me to, I won't take you through each item. They are self-explanatory. The only items that I would draw your particular attention to are item 21, which is an addition to the existing Rule 129M, a new sub-Rule 5, which provides the Assembly may adopt detailed rules for Section 89 inquiries generally, or for a particular Section 89 inquiries, provided that such detailed rules are compatible with sub-rules 1 to 3 above. That presages the second document that we will be dealing with tonight, which is the detailed rules, which are crafted as detailed rules for Section 89 inquiries generally. And the other provision that I would draw your attention to specifically is item 25, and that is the suggested replacement of the existing Rule 129P with a rule which reflects the legal status quo post the Constitutional Court judgment. The first rule sub-rule does not deal with a matter specifically mentioned in the judgment, and I draw attention to that particularly. That is the rule which permits the Assembly to alter decision taken by the Speaker in terms of Rule 129K1. And if you turn back to item 13, that says the Impeachment Committee consists of the number of Assembly members that the Speaker may determine, subject to the provisions of Rule 154, provided that all parties in the Assembly must be represented, And as I'm sure everyone knows, Rule 154 is the rule which requires proportional representation of parties in committees. So that determination of the number of members is something which the committee may, which the Assembly may reconsider and if it so decides alter. But by contrast, for instance, the Speaker's decision to refer a matter to an independent panel, such as is, and that's item 5, Rule 129C1. So in other words, once the Speaker is satisfied that the substantive requirements for such a motion set out in the preceding rule are met, that the Speaker must then refer the motion. So she needs to be satisfied that the motion is in order, and then follow certain other provisions which permit the Speaker and require the Speaker to appoint the independent panel and to appoint the chairperson. Those are not subject in the proposed Rule 129P1 to reconsideration or alteration by the Assembly. And the reason why I respectfully suggest that the Speaker's decision on those matters be final is that the rules, the general rules, contain detailed requirements as to the composition of that committee. They must be experienced and unimpeachable senior lawyers. But it's so as to safeguard the independence of the panel. So that is not a political decision. It's a function which the Speaker must perform in her capacity as the leader, effectively, of the House with constitutional responsibility. So I thought I should draw that particularly to your attention. The rest of 129P simply states the law. The Assembly is bound by a conclusion in the report of a panel that sufficient evidence exists as contemplated in 129G. That is the finding of the Constitutional Court in the recent litigation. And then turning to the Impeachment Committee, the sub 3, the Assembly is bound by a finding in a report of the Impeachment Committee regarding the charges in the motion calling for the removal of the President from office in terms of Section 189(1) of the Constitution. You will recall that the Impeachment Committee has to do two things: makes findings regarding the charges, and if there's a finding of guilty on any of the charges, make recommendations particularly. And then sub 4 then makes it clear that the Assembly is not bound by a recommendation in a report of the committee as to whether or not the President should be removed from office. But then there's a proviso: the Assembly may vote that the President be removed from office in terms of Section 89(1) of the Constitution only if the relevant report of the Impeachment Committee finds that one or more of the charges in the motion calling for his or her removal is established. And that is, of course, consistent with the constitutional function of that committee, which is to determine the veracity of the charges and, if necessary, their seriousness. Thank you, Madam Chair.
Thank you very much, Honorable Advocate Breitenbach SC, for your presentation on the suggestions for the amendment of the presidential impeachment rules. Mr. Kaso, is there something that you want to say before I give members the chance?
No, ma'am, there's nothing that I wish to add at this point. Thank you.
Okay, thank you very much, honorable members. I think we have these documents and we have noted what the SC was presenting to us. Can I then take hands? If there are any hands that I can take. Honorable Michalakis.
Is it only mine? Thank you, Chair. Chairperson, firstly, I am quite happy with the document. It's excellent, and we are quite happy to adopt it, there is just one amendment that I would like to propose, and that is in terms of item 13. Now, I do understand that this
Item 13 on which page?
on page 4.
Page 4.
Or paragraph 13. Now, I do know that this gives effect to the Constitutional Court judgment. However, the House is also entitled constitutionally to make its own rules, and it's within that discretion that I would like to propose my amendment. Now, in terms of Rule 129E, the panel itself needs to consist of people that are fit and proper, which is a legally defined term. I do think that this is not just an ordinary portfolio committee, and I do think that the requirement for this committee to serve or to function with integrity and a higher ethical standard is important. And I would like to extend that requirement that there is on the panel members to clause 13 by including after the word of the words fit and proper before the word assembly. So it reads, the impeachment committee consists of the number of fit and proper assembly members that the speaker may determine, subject to the provisions of Rule 154, provided that all parties in the assembly must be represented. That would be my only proposed amendment to this document. Other than that, Chairperson, we think it's an excellent document, and thank you very much to the team who put it together. Thank you.
Thank you very much, Honorable Michalakis. Honorable Ghana.
Thanks very much, Chair. Just maybe two things, especially on item 21, because item 21, that's on page 5. So currently it's not there. And maybe to understand, it's an option, as we present it. I want to understand that's an option. So it's not to say that the assembly must adopt the detailed rules. It may if it wishes to. So that the reason I say this, Chair, it's to allow, for instance, the committee to also make its own way of operating and procedures, and not everything has to be tied to the National Assembly. Just to understand that it's the way you have worded it. It's if the assembly it so decides and it's so required, may want to adopt the rules, but still gives a space for the committee to determine how it's going to conduct its own affairs. I say this in a sense that if the committee itself, those powers of determining how it's going to conduct its own affairs is taken over by the assembly, it might find to be, maybe in conflict with existing rules. So just need to clarify, because is this a necessity in your view? Is this necessary, or it's something that it will be desirable? Obviously, the court did not express itself in this, so this is not a consequential amendment. So the court did not say anything on it. So we are bringing it in. What is its effect? And if it was not there, does it make the committee's work maybe somehow suspect to challenges and so forth? So that's because we will get to the figure document. I put this so that you note it. This particular point, it was not part of the discussions in the Constitutional Court. Let's be clear, what are we trying to achieve with that role? On what Honorable Michalakis raises, I think it's something that obviously we have to, it's a proposal, and as we embark on this, one will not have difficult with it, but there are legalities on it, and we need to square it in terms of members of parliament serving in committees and so forth. So yeah, I think those are the 2 points. But otherwise, I'm happy, and I think, Chair, maybe as a final thing, to say we need to separate the 2 documents. We need to separate the 2 documents. The main rules, we need to accept the main rules separately from the detailed rules. So that when, and if it goes to the rules committee and we've all agreed that the main rules are in order, then they can go through the rules committee and go to the assembly, and not be, let's call it, delayed by the detailed rules, which I will submit that detailed rules might very well find itself better expression in the committee itself, rather than, whilst I appreciate them, they might find better expression through the committee process than through the National Assembly process, as you suggest with paragraph 21. That's what I will submit, that we separate the 2. We deal with this one, we accept it, and let's not try to twin it with the detailed rules, so that we speed up the process. I think South Africans expect us to come out of this meeting with something, and not then deal with the detailed rules. Thanks, Chair.
Thank you very much, Honorable Kana. That is why I said, let's take the rules separately. I separated them. Then on my list, I can see you are now raising your hand, Honorable. I'll come to you and Honorable Manyi, Honorable Mika, followed by Honorable Manyi, and the last one on this matter will be Honorable Matias. Unless if something comes up. Honorable Mika.
Thank you very much, Chairperson. We really want to second the adoption of this document as the general rules, and we will second the motion raised by Honorable Michalakis, and there's a reason for that, that class. When we elected the chairperson of the committee, I did raise that there must be some legal consultation on the fit and proper to be in the impeachment committee, because there is a case that already the courts have they did make a definition clear of who is fit and proper. But if you remember, there was a letter that was written by the DA, and to resolve that issue, I agree with insertion of that proposal, and the speaker must continue with that responsibility of whether that case and the courts having identified who is fit and proper, will it apply to this kind of, to this specific case? I don't want to go to the specifics of what I'm talking about, but we support this insertion of that point. I also want to agree with Honorable Ghana that the two, and yourself, Chair, the two must be separated. You know, we can come with rules here, adopt them, but at the end, the impeachment committee itself has a right to come with terms of reference. So the flexibility that Honorable Ghana is talking about must be there, so that we don't fight in the impeachment committee and say, what we came with is cast in stone. You can't change them and all of that. we will have to give the impeachment committee that leeway to apply its mind on the terms of reference as well. So in short, we would really love to adopt this document with the proposed amendment. Thank you.
Thank you very much, Honorable Manye.
Yeah, thank you, Chairperson. In fact, I'm glad, Chair, that I finally listened to your guidance that I should wait my turn. Because what the lawyers have said has actually touched on the point of alignment that I was talking about. Because on the 3 points that Advocate Brettenbach spoke to, he spoke to alignment of rules with the Constitutional Court, consistency and all of those things with the Constitutional Court and all of that judgment. And the point I wanted to make here is that also what maybe we don't say enough about it here, but probably it was said last time. It's like this process here, and this is the issue for me. It's like what we're doing here is a process that must precede the work of the impeachment committee. Now, I want to argue very strongly, Chair, that that posture is legally flawed, that posture. The posture that the impeachment committee cannot start until we do this process, until we do this process, the Chair has not stopped me. Until we do this process, I want to object to that. And I want to call the Chair to look at the Constitutional Court judgment, paragraph 7.
Chair,
the order-
point-
Honorable Manye, I really didn't want to stop you, but there is a point of
and I'm not
order
going to be
here.
frustrated here, Chair.
Honorable Manye, you are not going to be
Honorable
frustrated.
Mothaule is here to make sure that I
Honorable
make my
Manye,
contribution.
Honorable Manye,
He is not
I'm
going to
calling you to order now. What you are saying is really untrue. There is nowhere on the rules that I hear that is saying the committee, the impeachment committee will not work until we adopt the rules. There is nothing like that. I don't want us to mislead South Africans out there. Honorable Manye, I really don't want us to do that.
No, but this is implied, Chair.
There is nowhere on the rules that have been presented to us
we-
that is saying the impeachment committee will
process-
not work until
this
the
process-
process is finalized.
This process is actually in contempt of the Constitutional Court.
Honorable Manye,
No, Chair,
Honorable
you
Manye,
must give me an opportunity to
Honorable
make a
Manye,
submission.
it's
I'm making a
because you are
submission.
misrepresenting the facts.
No, this was, this,
Honorable Manye,
But
the impeachment committee elected a
you're not allowing me to
chairperson
speak.
this week on Monday. So there is nothing that has stopped the committee from working. I don't want you to come with your own understanding of what we
No,
are dealing
Chairperson,
with here.
I
Please,
disagree.
Honorable Manye.
No, Chairperson, the legal advice last time, the reason we are here
Chair, I
is
raised the
because
point of
the legal advice last time said, this is a process that we must go through to
Chairperson,
enable the impeachment committee to start.
raised the point.
And I am saying
Honorable
that
Manye.
process
Honorable
is
Manye.
legally flawed.
Honorable Manye, last time when we were in this meeting, we gave the team instructions of what they must do. There was nothing that was saying the process should not proceed. The committee cannot proceed. And on Monday this week, we were here at 2:00 to elect the chairperson of the committee.
But the
There is nothing, Honorable Manye, that is stopping the committee from operating.
Why are they not operating?
Honorable Mahlaule, you have a point of order.
Thank you. No, Chair, I'm raising a point of order on Honorable Manye that when we left last time, we had exhausted the point that he is raising and clarifying that this is a sub-rules committee which is sent to process finer details of what is going to be presented to the Rules Committee. So we have been mandated by the Rules Committee to come and sit here and deal with this point. Whether this point that he is passionate about, whether it delay tactic and all of it, doesn't belong to this sub-rule committee. We have been mandated to deal with the sub-rules, and I think we must stick to that. If one has lost a discussion last time and went to the friends and they advise on legal issues, and today we must believe that the same person who lost a discussion last time will convince us otherwise today because they met somewhere. It's not going to help. We'll go back and forth every day. We are here. We have said that the lawyers must go and do what they did. They are presenting. It's time to deal with the contents of what is before us, not theatrics. Thank you.
Thank you very much, Honorable Mahlaule. Honorable Manyi, can you please put your hand down? Thank you. Honorable members, these are the rules that some of the members have already moved for the adoption of these rules. The impeachment committee will meet and do its work irrespective of whether we have finalized the rules or not. Today is Thursday. We met on Monday to elect the chairperson, and that is done. Today we are here to adopt the rules as per the Constitutional Court judgment has directed. Members have already moved for the adoption of these rules. There's no need for us to go back on the discussions that we had last week, of which the team has dealt with the issues that we raised. From this meeting, we are taking, Honorable Manyi, can you put your hand down? From this meeting, as the subcommittee, we are going to take these rules to the Rules Committee, which will meet as per the determination of the Speaker. From this committee, these rules as processed by this subcommittee is going to the Speaker. She will call the Rules Committee, where these rules will be adopted formally. So let's not delay the process, because when we go back and forth with what we discussed last week before the team came up with these rules, then it's not going to assist the process. You are actually delaying the process, Honorable Manyi. We want to move so that we can discuss the other set of rules as proposed. Honorable Manyi.
Thank you, Chair. The first point I want to make here, I'd really like to challenge the legal team here to identify the precise constitutional authority for delaying the implementation of the Constitutional Court order, because the notion that the Constitutional Court said we must do this is actually unfounded. There is no directive from the Constitutional Court, Chair. I think you are misdirecting yourself and you're misdirecting the meeting. The Constitutional Court on order number 7 was very clear that the Section 89 must just be handed over. That's the first thing. Secondly, in terms of the rule, the Constitutional Court has done a read-in. A read-in is the law. This sub-rules committee has got no locus standi to second-guess the Constitutional Court. So the Constitutional Court has given us the rule. It has read it in. We are now pretending as if we don't even have that rule. We're like starting on a clean slate. I object to this, Chair, vehemently so.
Okay. Honorable Manyi. I'll repeat it again until you understand. If you don't want to understand or listen other people's views, then it's going to give us a problem in this meeting.
The view should.
No
It's
one,
mutual. You must also understand
Honorable
mine.
Manyi,
You must also understand mine.
Honorable Manyi,
I must get the input.
if
sheet
you
that
don't want
gave-
to sit in this meeting, please take your bags and leave.
No, this is not your meeting. This is the
Honorable-
Parliament's meeting.
I'm chairing this meeting.
So doesn't make it your,
Honorable Manyi,
doesn't make it yours.
Honorable Manyi, I'm saying, if what you are saying when
Yes,
that we are delaying this matter
Chair.
Yeah.
because
Call an order, please.
we
You can't-
disregard-
you can't, when you are speaking, Chair, there's a mic that is on.
can you
And,
please
and,
switch off
and
the
that will
mic?
promote dialogue. Can it be switched off so that you make a ruling and then we proceed?
Honorable Manyi, I'm saying, if we were going the route that you are saying when we are following it, the impeachment committee wouldn't have met to elect the chairperson. But to show that no one is disregarding the constitutional court judgment, the impeachment committee sat and met. There is work that is being done behind the scenes. Unfortunately, you are not the chairperson of that committee, and the chairperson cannot report to each and every one of us what is being done behind the scenes. So please don't drag us back. The impeachment committee is not going to wait for any rules. They are proceeding with the work. So please, Honorable Manyi, I want to move to Honorable Matthias. Please, Honorable Manyi, no. Honorable Manyi, no.
I have had other points here, Chair.
Honorable
But
Manyi,
I had other
I
points,
gave
Chair.
you an opportunity
not
to
done.
make inputs.
I'm not done.
to what has,
Interrupted, Chair.
can you please
Interrupted.
make an input
Yeah.
on what has been presented, not something that you came up with.
Okay, thank
Can
you.
you please switch off the mic?
But you
I
said must
didn't
make an
ask you to
input.
speak.
You said I must make an.
I didn't ask you to speak
You said I
now.
must make an.
Honorable Manyi, please. Honorable Michalakis.
Thank you, Chair. I want to raise a point of order. The rules that apply to the House apply to the committees as well, and I arise on Rule 69, which relates to grossly disorderly conduct, which indicates that if a member refuses to adhere to the decision of the presiding officer and constantly and consistently refuses to follow the instruction and the ruling of the chairperson or the presiding officer, that it constitutes grossly disorderly conduct. And I would like your ruling in that instance, because if a member then persists after that, then they should leave. Thank you.
Thank you very much for those interventions. I really wouldn't want us to go the route that you want to force me to. And I will not allow the meeting to mislead. I will not allow anyone to mislead or misrepresent this committee. I wouldn't allow that. So if you still hold your views, those are your views, not the views of this committee. And I want to plead with you. Let's respect one another. And also, let's make inputs based on this document. Thank you. May speak based on the
Yeah.
document.
Thank you, Chair. In fact, the other point I wanted to make here is that on item 21, I agree with Honorable Ghana's anxiety in terms of separation of processes. That this item 21 must be a completely separate thing here. And my worry is the use of the word may. Because if you look at item 21, and then you also look at the last one here, what's that one? 25, paragraph 4. That assembly may vote and so on. So this may is not as straightforward as you may think. Some of the mays has got some peremptory elements and all of that. So I think although on 21, you might think that it's an option but the lawyers might just find a way of making it less of an option and all of that. It can be something that just creates unnecessary tension. So I really just think that we need to find a way to do a Chinese wall, that when we finish with the rules here, we are not going to be bogged down, because also, Chair, my worry again is that the detail of this other document here, which is given rise by this Rule 21, may actually even conflict with the judgment. If you go to the judgment, paragraph 140 of the judgment, which talks to the impeachment committee being a distinct body with its own processes and what have you. Some of the things that are contained in this 39-page document are things that, in terms of the judgment, are envisaged to be done by the impeachment committee itself, Chairperson. So I'm suggesting that maybe we should actually cut out this 21, because it's going to confuse the processes, and I'm saying it will also conflict with the paragraph 140 of the judgment, which gives the impeachment committee a leeway to do its own processes as it were. Here we're doing a serious micromanagement. We're even talking about evidence leaders and how to deal with witnesses and all of that. So I don't think the process that we're busy with here should be encumbered at this point with this point 21. Thank you.
Thank you very much, Honorable Manye. Honorable Matthias.
Thank you so much, Honorable Chair. Honorable Chair, when you follow the draft agenda, item 3 deals with consideration of submission on draft rules to regulate proceedings associated with section 89 of the Constitution. And if you want to limit our inputs and discussions to what is being proposed here by the legal team, it forbids us from discussing what parties were invited to do, which was to make written submissions in relation to additional provision to matters of the National Assembly's rules. Now, before I can even want to comment on these proposed amendments, I would like to find out, one, such written submissions have they been considered? And if yes, to what extent have they been considered? If not, why? And if not, when are they going to be considered? I think perhaps that will be the starting point before I can even proceed further, because I want to comment on one or two aspects of the suggestion for the amendment on the impeachment rules. I hope you'll give me a second bite, because I have not even started to comment on.
Thank you very much, Honorable Matthias. We are not dealing with the thick document, of which I believe, but the legal team will have to respond to. We are not dealing with the thick document now. We are still going there. We are on this one. Yes.
Thanks with your answer, Honorable Chair. I would further want to and this is what I've also asked on Mr. Castle, whether have the legal team or his office established the chart process flow so that nothing will stand on the way of the impeachment committee to do its work. The chart process flow will guide not only the impeachment committee, but even this sub-rules committee as what is the rule ahead, the route ahead. So I'd like us to be provided with that chart process flow, which guides the process step by step. As this process we're busy with should run parallel to the work of the impeachment committee. The chart process flow will tell us whether the concerns expressed by Honorable Manyi of attempts to delay and frustrate the process, such is not the case, but we can only know if we're provided with the chart process flow. Let me comment further on what has been tabled before us. Look, if you read, I will directly go to page 6 and 7, Honorable Chair. Paragraph 25, which deals with Rule 129P. When you read that, and you read bracket 1, bracket 2, bracket 3, all three of them are consistent that the assembly is bound by a conclusion in the report of a panel that sufficient evidence exists as contemplated. And bracket 3 says the assembly is bound by a finding of in a report of the impeachment committee. But when you read bracket 4, it says the assembly is not bound by a recommendation in a report of the impeachment committee. I find bracket 4 to be in contradiction with bracket 3 and 2. Can you please get clarity in respect of that? But then lastly, I agree with Honorable Ghana with Rule 21 as it is, and it as it takes the Constitutional Court judgment forward, that the task of the Subs-Rules Committee is to insert the read-in that has already been provided by the Constitutional Court. So we don't have to be looking for something which is non-existent. It is there, it's written. All what we need to do is to read that in. Thanks, Honorable Chair.
Thank you very much, Mr. Kaso. I'll now hand over to you and the legal team to respond. Thank you.
Chair, I will deal with the process flow, with your permission. As we all know, honorable members, the committee is now fully constituted. So members were appointed, just elected the chair. Today, we are dealing with these rules, general rules. And if this committee agrees, the Rules Committee will meet on Tuesday to adopt the rules, because rules must finally be adopted by the House. And all things being equal, the House should consider these rules on Thursday, adopt them. Now, as to what happens with the impeachment committee, the rules in Rule 167 F say a committee of parliament has the power to determine its own working arrangements. So it is up to that committee. It's now fully constituted, it has a chairperson, it has membership to decide when and how it meets. Matthias said, did I assist?
Thank you very much, Mr. Kaso. Advocate Breitenbach SC.
Thank you very much, Madam Chair. A couple of inputs related to 129, the proposed new 129M5, item 21. The Assembly may adopt detailed rules for Section 89 inquiries generally, or for a particular Section 89 inquiry, etc. And the question was raised as to whether that may means must, in the sense that the Assembly is bound to do that. A related question was, in the absence of any such detailed rules, could the committee determine its own terms of reference, as if with a blank slate, as it were, obviously bearing in mind the content of the rules that we're discussing at the moment? I think it's as, and also in connection with the may possibly meaning must, or perhaps must not. We were referred to paragraph 140 of the judgment of the Chief Justice, Justice Meyer, in the matter that has brought this committee to do its work. The may means may, and it is consistent with section 50, and that is because it must be interpreted consistently with the Constitution. And section 57(1)(b) of the Constitution provides, as you know, that the Assembly may make rules and orders concerning its business with due regard to representative and participatory democracy, accountability, transparency, and public involvement. And that is what has happened, and will happen if these rules that are amendments we're currently discussing are made. Section 57 must be read, however, with section 59(1)(a), which says that the National Assembly must facilitate public involvement in the legislative and other processes of the Assembly and its committees. And what we are talking about here is one of those other processes of an Assembly committee, being the impeachment process in the impeachment committee. So just sticking to the answer for the moment, the question, the may means may, and the proposal put to you is deliberately separated the amendments that the legal team believes need to be made to the impeachment rules as they currently exist, the document which it suggested be amended, from detailed rules. And when we get to the detailed rules, I will give you my opinion on the rules versus terms of reference or some other form of regulating the process of the impeachment committee. In other words, what form that may take and, in my opinion, ought to take. But the important thing for present purposes is that section 129M is consistent with section 57(1)(b) of the Constitution. It states something which is states with specific reference to section 89 enquiries, something which is covered generally by section 57(1)(b), namely that the Assembly may make rules concerning that. As regards paragraph 140 of Justice Meyer's judgment, you'll recall on the last occasion I pointed out that although Justice Meyer spoke for members of the majority, she and those who concurred with her did not constitute the majority. There's another majority judgment by Justice Majid. And together, the judges who concurred in those judgments concurred in the order made, and they constitute the majority. But it follows that the parts of Justice Meyer's judgment which are not echoed or affirmed in the Justice Majid judgment don't necessarily constitute the reasoning of the Constitutional Court. And it is difficult, as I mentioned on the last occasion, sometimes when one reads these judgments, to answer that question with any specificity. But what I can say is this. The issue is whether paragraph 140 leaves it to the impeachment committee, either it says so expressly or by necessary implication that the impeachment committee must determine these rules. I do not see that stated expressly, and it is also not without significance that the issue being discussed in paragraph 140, namely what could be done if the evidentiary basis underpinning a motion calling for the president's removal, despite having been found prima facie by the independent panel, doesn't survive initial scrutiny by the impeachment committee. And what is then discussed is what is colloquially perhaps could be described as an early off-ramp from the process. And that proposal is made by the Justice Meyer and the colleagues who agree with her. But what is significant is that in the very next paragraph, what the learned Chief Justice said is that in such an instance, if appropriately regulated by the NA rules, the termination of the inquiry without a full-blown trial may well be justified. And what, in other words, she was saying is that there can be rules which regulate, NA rules which regulate aspects of the impeachment process, as indeed the rules did that were under consideration in that case. So my last word on this aspect is that this is something which can be regulated by rules. This being a Section 89 inquiry. Section 57, 1B of the Constitution, read with Section 59, 1A, says so. And secondly, in this very judgment, the making of further rules is contemplated and mentioned. I have no comment on the proposed insertion into Section 129K1 of the phrase fit and proper before the phrase assembly members for two reasons. The first is I would have to reconsider the judgment in the case to which reference has been made before I could do that. And secondly, it is assuming it's permissible, it is something which on which a political decision will have to be taken. So with respect, my request, Madam Chair, is that if necessary, then constitutional and legal services should be asked for an opinion on that. As to the question whether written submissions were considered, they certainly were. And they were considered before these documents that you have before you were completed and circulated. As to the question relating to the, on the face of it, I think it was put as an apparent inconsistency between the wording of the proposed new 129P4 on the one hand, which said the Assembly is not bound by a recommendation in a report of the impeachment committee as to whether or not the President should be removed from office, as against the Assembly is bound by a conclusion in the independent panel report that sufficient evidence exists, or the Assembly is bound by a finding in a report to the impeachment committee regarding the charges in the motion calling for the removal of the President from office. With respect, there is no inconsistency. The subject matter is different. The Constitutional Court has ruled, starting with the panel, that its decision on the prima facie evidence, the Rule 129G question, is final and binding on the Assembly. That is the basic outcome of the litigation that has just been concluded. As far as the binding nature of the impeachment committee's finding on the questions of whether the charges are established is concerned, you will recall that in the previous EFF cases, EFF2, one of the findings was that there would have to be a process through which there was an inquiry evidence-based into that question. And in the latest judgments, that is affirmed. So the issue of whether or not any of the charges is established is a matter for the committee. But the committee must make recommendations, and the question whether or not the president should be removed for office is something which is reserved by the rules as they currently stand to the members of the assembly. And that's rule 129.04. It says, if the report recommends that the president be removed from office, the question must be put to the assembly directly for a vote in terms of the rules. And if the question is supported by at least 2/3 of the members of the assembly, the president is thereby removed from office. And that is, of course, consistent with section 89(1) of the Constitution. So this rule makes clear what it is, basic elements of the structure created by the section 89 process structure. 3 basic elements. The independent panel decides the prima facie evidence question, should it go to an impeachment committee, binding. The impeachment committee decides whether any of the charges are established, binding, and makes recommendations to the assembly on whether or not the president should be removed, not binding. That question gets put to the assembly for a vote. Thank you, Madam Chair.
Thank you very much. Is it a follow-up? Oh, Mr. Klasso?
Just on that point, I also wanted to indicate that this approach, this paragraph 4 approach, is consistent with how the House deals with reports of committees. The House cannot change a finding of a committee, but it can amend a recommendation of a committee because committees are substructures of the House. Thanks, Chair.
That has been responded to. Honorable Ghana?
Thanks, and thanks, Advocate. I'm coming back on paragraph 21 to say, whilst I appreciate the spirit in which you make the proposal, if that rule, because currently it does not exist, it's not there. If we were to proceed in its absence, when it's not there, does it impede anything? And when we insert it, so this is where I come in, especially when you have to do the public involvement in the affairs, because that's where the concern is. When we insert it, can it open a tiny gap for someone to say, all right, the procedures that the committee has adopted to conduct its affairs are such that this 129M sub 5 was not complied with. So we might want to say, I'm happy with the document minus that part. So if we were to go to say, for this part, because now we've already started, we have the committee now and so forth. We say, for this round, let's go in without 129M5. So we park. So not that we completely sell it, we park it. So it does not go into the rules committee on Tuesday. So that part, it does not go in. We go in with the rules as they are, with the amendments as the Constitution has said, so that we don't open loopholes. Then in the background, we can then do a comprehensive relook at 129 in the background, because otherwise I think it might open a tiny hole. And I thus propose, Chair, that we accept the document minus paragraph 21. So paragraph 21 does not go into the report that the Rules Committee is going to consider. And then we will deal with it, not with the time pressures and so forth, because otherwise it might open ourselves up to other things that at the moment it's not there. Because for me, the current rules are sufficient for the committee to proceed with the amendments coming from the Constitutional Court. So I thus propose that paragraph 21, for the purposes of the Rules Committee, not be submitted for consideration by the House. Thanks.
Thanks, Honorable Ghana. Honorable Manya.
Yeah, Chair. No, I second the the suggestion by Honorable Ghana. Also because the paragraph 140, the articulations of paragraph 140 of the Constitutional Court judgment are not contradicted anywhere. And just, Chair, for the purpose of those that don't have it in front of themselves, there's just one sentence that says, once seized with the matter, the impeachment committee performs a distinct investigative function and subject to the NA rules, particularly Rule 129M, retains control over its own proceedings and scope of the inquiry. So this is why I hold the view that this thick document here blurs the line because it tries to regulate, it tries to do some of the proceedings and all of that, yet the Constitutional Court was not contradicted anywhere in terms of leaving that to the impeachment committee. So I think I'll also be comfortable if we took the document minus that point, that clause 121. Thank you.
Thank you very much, Honorable Manya. Honorable Matthias.
Well, Honorable Chair, maybe the problem here is English. It would have been good if we were to speak in our mother tongue. Allow him to speak in Xhosa and allow me to speak in Sesotho and allow you to speak in Sindebele or Tsonga. Perhaps we'll find one another. Look, there are three distinct words here. It's conclusion, and I refer to paragraph 25. Paragraph 25. That deals-
Paragraph 25.
page 6 and 7, that deals with Rule 129P. There are three distinct words here. It's conclusion, finding, and recommendation. With conclusion and finding, what is written is that the assembly is bound. Okay, let me read this in full. Bracket 2 says the assembly is bound by conclusion in the report of the panel that sufficient evidence exists as contemplated in Rule 129G. Bracket 3 reads, the assembly is bound by the finding in the report of the impeachment committee regarding the charge or charges in the motion calling for the removal of the president from office in terms of Section 89. Subsection 1 of the Constitution. Bracket 4 reads, the assembly is not bound by the recommendation in a report of the impeachment committee as to whether or not the president should be removed from office. And furthermore, I'm saying there are three distinct ways which are interrelated. It's conclusion and findings, which according to this assembly is bound to accept both the conclusion of the panel and the finding of the report of the impeachment committee. But when it gets to the most critical part, the recommendations, this reading says the assembly is not bound. But I'm raising this for my own clarity. But if Mr. Kaso and Advocate Breitenberg agree with their understanding and interpretation, we'll leave that with the rider that should we get a legal opinion that is consistent with our own understanding and interpretation of this, we reserve a right to challenge this specific rule. But then lastly, I want to comment on what earlier, or it may not be related to this discussion, but it's important for fear of losing my time, my airtime. What Honorable Mikalakis raised earlier as the question of fit and proper. Let's not be opportunistic with what we want to smuggle in here. Let us not be opportunistic with what we want to smuggle. That matter of fit and proper is very unrelated to the work we're dealing with. Had any of the members of parliament be found unfit and improper or improper, that determination would have been made at the time when we were sworn in by the Chief Justice. And if that matter was not raised then, at that point, a member that was sworn in by the Chief Justice holds the same right and same entitlement as any member of this House. So I don't want us to opportunistically smuggle things that are not of this committee and are not related to the work of the committee. Thanks, Honorable Chair.
Thank you very much, Honorable DCW, Honorable Nkabane, followed by Honorable Mika Mahlaule.
Thank you so much, Chairperson of the sub-rules. I think I'm satisfied with the clarity that has been provided by Advocate, the Senior Counsel, in terms of some of the issues that have been raised by honorable members here. Because when you look at the context on clause 25.4, is different from what 25.1, 2, and 3 indicates in terms of interpretation, taking from what he has actually explained before us. Hence, we understand that the rules are derived from the Constitution, so there is no way we can contravene with what the Constitution says. 4 is based on section 89.1. That's why it says here, the assembly is not bound. Because we need to meet this requirement as the provision of section 89.1, where it says the National Assembly, by a resolution adopted with a supporting vote of at least 2/3 of its members, may remove the president from office only on the following grounds. It then means whatever that we're going to do, we need to meet this constitutional requirement, which is then going to be the basis of us then taking that decision. Then it means the draft that has been tabled before us, Chair, I fully support it. Let's take it as it is. Thank you.
Thank you very much, Honorable Mahlaule.
Thank you very much, Chair. I think the first point that the Deputy Chief Whip has dealt with covers what I wanted to say. It's not a matter of language, Honorable Matias. I think it's a matter of comprehension of the difference between the 4 sentences. And it becomes so because when you come to the 4th, and it's the second time, the fourth sentence, you don't complete it when you read it. You deliberately stop somewhere and not complete it. And if you do so, it conveniently covers what you want to argue. For the second time, I'm listening to you and the clarity there. That's why we will never reach the point that the council is arguing that there is nothing wrong with using bound findings and all of that. And when you get to the conclusion, you say it's not bound because it has a rider provided that the assembly, you don't read that. And I don't know whether it's deliberate or what, but she has covered it that it's read in line with the constitution. The second point that I don't think I should leave it because as much as it's not directed to me, because I raised it in the impeachment committee. You know, the ANC was part of people who said Judge Hlophe is eligible to do anything, to be in any committee in parliament because he was sworn in by a judge. That was in relation of him going to the JSC. We agreed then. The only reason why we're raising that the speaker must go and look for a legal opinion is that the courts decided otherwise on the JSE. That's why Judge Hlophe is not serving in the JSC. There was an order that says we as parliament were not supposed to allow him to go there. That's why we're saying this time on this committee, and different to not wanting him to serve. On the side of caution, let's have a legal opinion so that even on this impeachment committee, judges don't arrive at the same conclusion, be it that this matter is taken far to courts. That's the only thing that we are dealing with here, and we are requesting that the speaker must seek a legal opinion on this one because we have lost that one. Actually, it's not a political party that lost. It's the National Assembly that lost. And this time, we must not be found on the wrong side of the law when we have an opportunity to seek legal opinion on the constitutionality of what we are doing. And it bothers really on the side of caution, not anything else. Thank you.
Thank you very much, Honorable Michalakis. I want to close this matter.
Thank you very much, Chair. No, just on the submission made on my earlier amendment, Section 47 of the Constitution does not make that requirement specific for members of Parliament to serve. However, I did indicate before I proposed the amendment that this specific committee requires a higher standard of ethics, in my opinion, and a higher standard of integrity. So I stand by my submission, and I want to thank Honourable Motlaule for seconding that amendment. Thank you very much.
Thank you very much. I made a ruling last time when we met, and I'm still going to make a ruling on this matter. I don't want us to keep on discussing a person. Allow me to make a ruling on it after the SC's response to the questions that were posed. Do you have a follow-up question? Okay.
No, I actually wanted to support Honorable Matlauli that because sometimes things are situational. There's a decision that gets taken because of a particular context. But I think he's saying let's err on the side of caution. And I don't think anybody that is reasonable can argue with that. Therefore, we take this matter to lawyers outside this house, independent, and then they give us an opinion now.
Thank you very much for your understanding. Advocate Breitenbach.
Thank you, Madam Chair. I again won't speak to the proposed fit and proper amendment. I note that that may well be the subject of an opinion, as I mentioned previously, and that opinion will doubtless consider whether the reasoning in the case in question is transposable or should be transposed to the current situation. On the, there were 2 points that were raised in, I'm going to deal with them in reverse order because the second relates to the thicker document, the detailed rules, and you may rule, Chair, that it's best that I speak to that point when we reach that point. There was again question raised about sections 129 sub 2, sorry, 129P sub 2, sub 3, and sub 4. You will recall that is the provisions which relate to the Assembly being bound by conclusions in the panel's report, bound by findings in the Impeachment Committee's report, and not being bound by recommendations in the Impeachment Committee's report. And the question was asked, why the variation in language? As far as the use of the word conclusion in section in 129P2 is concerned, the word conclusion comes from section 129, rule 129I2. Sorry, 129I sub 3 and sub 4. You'll recall that is the rule which the Constitutional Court read into the NA rules. 129I starts in the event that the panel concludes that sufficient evidence exists as contemplated in Rule 129G, and that wording is mirrored in 129P2. The Assembly is bound by a conclusion in the report of a panel that sufficient evidence exists as contemplated in Rule 129G. So it's a direct, derived directly from that. 129I4 deals with the contrary scenario in the event the panel concludes that sufficient evidence does not exist as contemplated in Rule 129G. And it goes on to say, the Speaker must schedule the report for consideration by the Assembly, and in the event the Assembly nonetheless resolves that a Section 89(1) inquiry be proceeded with, the matter must be referred to the Impeachment Committee established by Rule 129J for a Section 89 inquiry. So that's the converse situation. Rule 129P correlates, in other words, to the first scenario. The panel concludes that sufficient evidence exists, and that's binding. What is not binding, and that's made clear by 129I4, is if it concludes that sufficient evidence doesn't exist, the Assembly can still change that. Turning to the word finding in 129P sub 3, where does that word come from? It comes from the existing NA rules, which provide in 129O that the report of the Impeachment Committee must contain findings and recommendations, including reasons for such. Now, those findings are on the matter which the committee must determine, and that is, it must, 129M1, proceed to establish the veracity and, where required, the seriousness of the charges and report to the Assembly thereon. If such a determination would be, I think, appropriately described as a finding. One could replace the word finding with determination, but I think finding adequately fits the bill, and its use is indicated, preferred, because it would then be consistent with 129O2, which talks of the committee containing findings. And then you will already know the answer then to why the reference to recommendations. It's because that's what's already there in 129O2, 129O3 and 4, and as pointed out by one of the contributors, consistent with the scheme of Section 89(1), which leaves the final decision as to whether or not the President should be removed from office in the hands of the Assembly itself. Thank you, Madam Chair.
Thank you very much. Thank you very much, Advocate Breitenbach SC for those responses, honorable members. I think we have exhausted this discussion. I'm coming to it, please. We have exhausted our discussions on this matter. So going forward, the matter of fit and proper, as we have already dealt with it in our last meeting, and today also, we are referring it for a legal opinion, if that can be expedited so that we can move forward. Then the second matter is that we remove paragraph 21 on these rules, and then we adopt these rules as they are, excluding paragraph 21. We will then send them to the Rules Committee for adoption. Is there a mover for the adoption with the exclusion of paragraph 21? Okay. Is there a mover for the adoption of the rules with the amendment that has been made of fit on and proper, but that will be subjected to legal opinion? Is there a mover? And also with the exclusion of paragraph 21. Honorable Nkabane.
Thank you so much, Chairperson. I move that we adopt the rules and also consider the removal of section 21, and also that we need to seek legal opinion around those issues.
Thank
And
you.
the fit for purpose issue. No.
Thank you very much.
Chairperson, no. The matter before the House that was moved and seconded was the inclusion of the words fit and proper and the removal of Rule 21, subject to a legal opinion.
Yes.
That is what I'm seconding it. I just want clarity on that, but I will second if that is the clarity. Thank you.
Thank you very much. You have seconded the rules. Thank you. I said we adopt the suggested rules with the amendment made, subject to the legal opinion on the wording on this incision by Honorable Michalakis of fit and proper, that we are subjecting those inputs to legal opinion. Then secondly, we are excluding paragraph 21 as proposed. Are we in agreement? Thank you very much. Thank you. So now, Mr. Paso and the team, we are moving now into the detailed documents of the proposed rules as detailed here, but it will be safe for me to say, going through this document, Advocate, I don't wanna lie. There are many duplications that I hear, and some of the duplications, we do have them in our rules as they are, but that will be, as we will be discussing, we will indicate which one and which one. If you may take us through, I believe, Futhi, that the submissions by parties were incorporated in here. If not, they are still going to be incorporated because this document must be cleaned up and simplified. to make it workable for us parliamentarians, because as it is, it's really complicated and confusing, if I may say so. Okay.
Thank you, Chairperson. I just wanted to perhaps suggest, I don't know if the secretary would like to comment on, because members have made some observations about the nature of the specific rules governing Section 89 inquiries. And there was a view, I think, expressed that such rules or such directives would belong in some sense with the impeachment committee itself. So but I suppose I'm suggesting is how members feel about the status of this document, because if they feel that it doesn't belong with the Rules Committee, at least now, then would it make sense to go through the detail? But perhaps the secretary would have a view.
Mr. Klaas?
Chair, you will guide us, but I think Council would just like to highlight a few issues without getting into the detail of the document, so that at least you know what the document is about and what we have since considered after the document was circulated. Certainly, you must indicate whether the committee must meet again on this document, or it must be taken to another structure. You will guide us on that. But I think council is ready to just highlight a few issues. Thank you.
Through you, Advocate.
Yes, thank you very much, Madam Chair. This is a proposed set of detailed rules governing Section 89 inquiries by the impeachment committees. And it is drafted in a manner which, if one can put it colloquially, would be a one-stop shop, in the sense that it covers the field, sometimes by cross-referring to existing rules, but the thinking behind it is that if it were to be adopted, that the committee itself and people engaging with the committee, outsiders, would have a document which would provide a comprehensive framework for the work of this committee, which, as you know, is to establish the veracity and the seriousness of the charges, and to report to the Assembly thereon, and also to make recommendations to the President. What is unusual about this committee is that, and this is clear from judgments of the Constitutional Court, is that the members of the committee will be sitting in judgment on the charges against the President. The charges will not always relate, as you know, to misconduct, contraventions of the law or the Constitution. In some instances, they could relate to an inability to perform the functions of office. And you'll recall I mentioned earlier that in drafting them, the thinking was to provide a set of rules which would be fit for purpose for both. Given the work of the committee, its constitutional responsibility for conducting such an inquiry, among the issues that were considered were who should present the evidence, who should be entitled to participate as of right, and how the proceedings or process should unfold. What should happen when the evidence is concluded. Other matters that were considered were what evidence should be received by the committee. Should there be rules relating to admissibility of evidence? And there is a proposal in that regard. Rules to guide the deliberation and ultimately the decision-making. Oh, sorry, I should mention that after the evidence is concluded, the making of submissions, written and oral submissions to the committee, and then the deliberations of the committee. What are the matters on which there should be deliberations, and what should be reported on? And in a moment, I will give you an overview of the structure of the rules and the thinking behind it. But before I do so, I think it's important that I deal with the question which was raised earlier regarding whether these should be rules or not. The Constitution provides in section 57(1)(b) for the Assembly making rules and orders concerning its business. And in 59(1)(a) imposes the obligation, much litigated, on the Assembly to facilitate public involvement. An important feature of this process is that it necessarily will involve one outsider, the President. And it will also must make provision to the extent appropriate and in a regulated way for public involvement in this process. That is not an optional, it is obligatory. And for that reason, in my respectful opinion, it would be appropriate that rules are made. You'll have heard on the at the previous meeting, I said that, in my opinion, it would also be preferable if the rules are made in a considered and focused way, and not on the hoof, as it were, while the committee is busy doing its work. In other words, the rules of the game are determined before the first witness is led. And that those rules extend to the very important preparatory work which will make the impeachment inquiry either work or not work well. So, in summary then, I believe that it would be appropriate for rules to be used, and I believe also from the point of view of the public understanding of this process, that it, and also to assist the chairperson and members of this committee and those who engage with the committee, that the rules cover the field and do so in a way that anyone who wants to know what the next step is or what will be happening will have access to a document which is accessible. I'm sorry to hear, Madam Chair, that you found the rules difficult to follow. I can assure you that they were perhaps even more difficult to draft. But hopefully when if you give me a few minutes just to give an outline, things will become clearer. So this document is structured into 22 paragraphs. The first paragraph is a set of definitions, and they speak for themselves. The second sets out the legal framework. And what we have chosen to do is to first quote the most important sections of the Constitution, section 56, which has to do with evidence and information before the Assembly or its committees, 57(1) and 57(2)(a, to which I've referred. And you'll recall that I didn't mention it specifically, but 57(2)(a) says the rules and orders of the Assembly must provide for the establishment, composition, powers, functions, procedures, and duration of its committees. There's no doubt that the subject matter of these rules is the proper subject matter of rules of the Assembly. Then section 59(1), to which I have spoken, and 2, relating to public access to and involvement in the Assembly and its committees, and those are matters regulated in the specific context or proposed to be regulated in the detailed rules that you have. In section 89, its inclusion speaks for itself here. What then follows in section 2.5 is the rules, what I've called the general section 89 rules, in other words, the existing rules. But they must be read with footnote 1 to the definition of that term on page 2. So the definition starts at the bottom of page 1, but it's part 3 of chapter 7 of the Assembly Rules, in other words, the existing rules relating to impeachment, section 89 processes, and then as amended by the Assembly on, and you'll see a date has to be inserted, and that is as per the suggested amendments. It's the matter that we've just dealt with. So going back to paragraph 2.5 on page 5, what you have is how those rules will read if the amendments which have been discussed today are adopted by the Assembly. So if you have a pencil handy, I would recommend that you in section 1, rule 129K1, which you find on page 8, you pencil in between the words of an assembly, if I understood the proposal on which legal advice is being sought, you pencil in fit and proper, because that is a change not reflected here. And then at the bottom of that page, you delete sub 5, 129M5. It's of course not necessary for 129.5 to be there, because the rules can be, detailed rules can be made for the reasons that I've just explained. One has regard to section 57 of the Constitution in particular.
Advocate
Yes, Chair.
Breitenberg, I'm sorry to interrupt you like this. Thanks for the explanation that you have provided and the clarity. But I think I would advise that maybe you just summarize, because you are still going to do something about it, about this document. Then when we meet next time, we will be able to go through that. Or if you don't mind, I can advise the meeting on what I think needs to be done.
Madam Chair, I'm in your hands.
Okay. I wanted to say, Mr. Paso and members, that I think as the rules are detailed, as they are, I want to suggest that we allow the team to go and develop the framework of the terms of references, where all the inputs by parties will be incorporated, and also the committee, the impeachment committee, will be able to enrich those terms of references. I'm not sure if I'm making sense, honorable members. Honorable Mani?
Yeah, Chair. The first point I wanted to make, Chair, I think there are certain decisions that we've made as this committee, which I think we must all respect. And I think firstly, we've agreed that as we go next week, this point 21, that has got this detail, that is not part of the picture, tick a box. And I think we note the opinion of the senior counsel behind me. And I think, Chair, because my biggest discomfort with this detail is that I think it is a micromanagement of the impeachment committee. And I take you back again to paragraph 140, where the Constitutional Court was very clear and unambiguous that the impeachment committee is a distinct body of sorts, and it can determine all these things. Maybe this advice that the senior counsel is giving, he can give directly to the impeachment committee. Then they can deal with it at that level. Thank you.
Thank you very much, Honorable Ghana, followed by Honorable Masaule, then Honorable Michalakis.
Thanks very much, Chair. I align myself with what you are suggesting. Having removed paragraph 21, which refers to 129M5, so it's not going to go through to the assembly. We can then accept, so take this document in the same way that we have dealt with, I think there were two committees that were established. We gave a guide. So it's a guide that then will then go to the committee, and the committee will then enrich it. If it will benefit from the senior counsel and so forth, as it gets refined there. So we accept it as a guide, but if there's a refining that can happen to the committee working together with the legal services, then that work be done. Then what will then happen is that the document serves as a guide, and the committee might very well decide that let's then take it through the public involvement, if that is the main concern, whether the roles will be, or the guidelines for the committee will go through the public involvement. So we take that point in, and we can then at least table it to the committee. But then we accept this as a guide, like we did with the presidency committee. And I think there was another committee, Mr. Kaso will remind us of this.
The undertakings committee.
The undertakings
petitions.
committee. So the subcommittee on rules gave the guide to the committees, but it was not to say these are your rules, just to say these are the guide. You can then, at least you've got a framework. You've got something, you are not starting from zero. So I will propose that, having accepted the earlier point. Thanks.
Thank you very much, Honorable Masaule.
Thanks, Chair. I wanted to say exactly what Honorable Ghana is saying. I'm just worried sometimes the language we use towards people who have asked to do this work for us. Now we're calling them that they're micromanaging the situation. I don't think it sits well when you send people, you ask them to do a legal document, and then you just, their work is ridiculous just like that. I mean, this view that we are micromanaging, when we come out of here, it becomes part of the minutes of the committee, and I don't think it's a fair way of addressing some of the work that we should be appreciating. But I agree fully with the summary that you have made, Chair, and what Honorable Ghana has suggested.
Honorable Chair, it's not the matter of language, it's comprehension.
Didn't give you the platform, Honorable Matthias. Honorable Michalakis.
Thank you very much, Chair. Chair, I want to just refer to the very sound legal advice that Mr. Breitenbach gave at the last meeting of this committee, which was that if we want the Section 89 impeachment committee to run smoothly, we must ensure that we make provision for all eventualities and that it is detailed in what the rules of the game are before we start playing it. So therefore, I would recommend taking into account, I agree with Honorable Ghana that with the exclusion of number 21 or paragraph 21 of the previous rules, that it would be futile for this committee specifically to consider this as rules. However, that this committee can make a recommendation to the committee, the impeachment committee, to say that this should form the basis of our guidelines. I do think that that's quite important, that this work should form the basis of those guidelines. And I think we are in agreement on that, but I just wanted to point out that this is not micromanaging, it's not futile. This is actually the detailed rules that will make sure that the process itself is sound and is very clear from the beginning. Thank you.
Thank you very much. Honorable Dagmo.
Chairperson, it seems that Honourables Ghana, Mikalakis, and Mahlawule have covered me. I think this is important work that particularly the guidelines, as colleagues have raised, and I think as Honourable Manyi has raised, the issue of the issue of going through all of those submissions and then reworking, but distinguishing between what are rule amendments as per the Concord and what are guidelines. I mean, I'm sure Advocate Breitenbach and others realize we've got a book like this. So with what you've proposed, if they all become rules, it would almost become double the size. But it's just guidelines. But I agree with my colleagues that this isn't an attempt to micromanage. It's actually very helpful to have guidelines like that. Thanks.
Thank you very much, honorable members, for your inputs and also in agreement with the suggestion I made, and also that we take this document as a guideline for the committee, for the impeachment committee, and also that the team, Advocate Breitenbach, you did an excellent job. If you can just go through it once again, together with the 9th edition of the rules, you will see some of those duplication, if those can be removed. And also, Mr. Klaso and the legal team, if you can then go and develop the framework for the impeachment committee on the references, the framework on the references for the impeachment committee, and also considers some of the inputs made by parties, then the committee will proceed in that order. Thank you very much, honorable members. I think, Mr. Klaso.
So, Chair, next week, what we're taking to the Rules Committee are the rules that were adopted with the amendments. We will obviously develop a report, and we will make reference to this detailed document that it is going to the impeachment committee as a guide for them, or a framework for them to develop their own terms of reference. Is that the understanding?
Yes, that is what I suggested, to say that if you can come up with the framework for the committee, then they will enrich it themselves. Or we will enrich it in the committee because we sit in there. So that is what I was saying, Mr. Klasho. Advocate, I can see that you want to say something.
Nothing at all. I've heard what has been discussed and decided.
Okay, I just want also to apologize for our language sometimes as politician. We want to be radical sometimes, and also we attack people who will not defend themselves in a meeting. We should refrain from doing so. Honorable Mani, I hope you are not taking us back.
No, not at all, Chair. I've already packed my bag. I just wanted, Chair, in your ability to clarify things so that I leave here with a very clear position, that can I leave this room with the understanding that whether it was that section 89 that was sent to the impeachment committee, can I just take it therefore that the impeachment committee is seized with the section 89 report or not? Because that's really the issue for me. I just want to understand what is my take? Is it seized with it, yes or no?
Thank you, Mr. Klaso. Can you please respond?
Chair, the report is before the Section 89 committee. The impeachment committee, yes. The report has been referred to the impeachment committee.
Another question? Honorable Mai, like I said, honorable members, the work of the committee has started. It started on Monday after the elections of the chairperson, and there is work that is being done on the background. So let me take this opportunity to thank Advocate SC Breitenberg, or Advocate Breitenberg SC, and the team for the good work that you have done in assisting us to come to the conclusion of these rules, the suggested rules for the amendment, and also for the work that you are still going to do. We appreciate it, and we also value your advice. So, honorable members, we have adopted. The report will be sent to the Rules Committee, so we will be guided. As Mr. Klaso has suggested that the Rules Committee will meet on Tuesday.
We are likely to meet virtually.
Yes.
Yeah, on Tuesday, but Speaker must still decide.
Honorable Mahlaul, I can see that you don't want to go home.
No, I want to go, Chair. I just wanted to advise Honorable Mani that maybe in the next meeting, he must wear a suit because maybe this fighting is influenced by these gloves that he's wearing because it's misguided. Maybe a suit will be fine. Thank you.
Honorable Mahlaul, the meeting is adjourned.